Noong July 2001, bumisita ako sa Barangay Datang sa South Cotabato, ito sa munisipyo ng Tibuli. Pagdating ko doon, naabutan ko na umaapoy pa yung baryo. No? Kalahati ng baryo naabo na eh. May natitira pang iba, pero nung dumating ako doon, nakita ko na yung kapilya nila unti-unting nawawala na, at nakita ko rin ang eskwelahan nila ay abo na. No? Nung pagdating ko nga doon, nakita ko ang mga bata nagtatakbuhan, ang mga nanay, ang mga tatay, abala na maghanap ng paraan para mapatigil yung apoy. Pero hindi nila kaya. Sobrang mabilis ang pangyayari. Yung mga nanay wala nang magawa, umiiyak na lang dahil nga hindi nila alam kung anong gagawin nila. Yung mga bata nagkalat doon sa lugar. Yung pala, ang nangyari, pinapalayas po yung lahat nitong mga katutubong ito dahil sinabi nga na squatter daw sila sa sarili ng lupa. Nagdala ng traktora yung mga sundalo at ang ginawa yung mga pananim ay sinira lahat, walang tinira. So wala nang bahay, sinunog lahat ng bahay, lahat pa ng pananim binunod. Talagang ginawa ang lahat para mapalayas yung mga katutubo doon sa lugar na to.
In the Philippines, there are about 110 ethno-linguistic groups with a combined population of some 10 to 12 million. Over the years, these indigenous peoples, or IPs, have lost a large part of their ancestral domains. Ancestral domains refer not just to land, but to bodies of water, forests, mineral and other natural resources within the boundaries of what has traditionally belonged to an indigenous community. The privatization of land, mining and logging operations, and land reclassification have driven off thousands of IPs from their homes. Encroachment by migrants is another problem. The indigenous community welcomes the migrants, not knowing that the visit would be a permanent one. As a result, indigenous people have come to regard all migrants as land grabbers. The situation is not as clear-cut where the government awards ancestral domain areas to landless migrants under the Agrarian Reform Program. This documentary will relate how an apparent mistake by the government in awarding ancestral lands to Agrarian Reform beneficiaries, or ARBs, has led to conflict between this group and indigenous peoples. Landless farmers and IPs are two of the poorest sectors in Philippine society. Not coincidentally, their poverty is a result of their insecure tenure on the land. Two laws seek to address this problem. The Comprehensive Agrarian Reform Law, or CARL, which was passed in 1988, aims to distribute 10.9 million hectares of agricultural land to tenants and farm workers. The Indigenous Peoples' Rights Act, or IPRA, which became law in 1997, recognizes and seeks to protect the rights of IPs to their ancestral domains. The Department of Agrarian Reform, or DAR, is the lead implementing agency of the Agrarian Reform Program, while the National Commission on Indigenous Peoples, or NCIP, is responsible for implementing the IPRA. Given the distinct mandate of CARL and IPRA, why are the land rights of IPs and farmers coming into conflict?
The Philippines has 30 million hectares. We have an estimated population about 87 million. Imagine if you just divide that, you total less than a hectare for each person in the Philippines today.
Lahat ng tao kasi kailangan ng lupa para mabuhay. Yun ang problema, no? Ang malungkot lang nito ay halos lahat ng magagandang lupa, all of the good arable lands, still remain sa kamay ng mga mayayaman, no? Dahil hindi magtagumpay ang CARP sa kapatagan, wala silang choice kundi maghanap ng ibang kabubuhayan, no? Saan sila pwedeng tumakbo? Sa kabundukan, sa lupa publiko. Ang masakit lang nito, may katutubo dyan. Sila naman yung nasasagasaan.
In 2002, the Asian NGO Coalition for Agrarian Reform and Rural Development, or ANGOC, implemented a project called Pursuing Land Partnerships in the Philippines, Finding Common Ground to Address Land Conflicts Between Farmers and IPs. This project sought to investigate the reasons behind conflicting land claims and to find ways of settling such conflicts peacefully. The project was implemented in partnership with the International Land Coalition based in Rome and other Philippine-based NGOs, such as the Philippine Association for Intercultural Development, the People's Campaign for Agrarian Reform Network, the Foundation for the Philippine Environment, and the Foundation for a Sustainable Society, Incorporated. ANGOC selected 2 areas in the Philippines where the conflict between ARBs and IPs was greatest. These were the Don Carlos Estate in Bukidnon, Mindanao, and the ancestral domains of the Buhid Mangyans in Oriental Mindoro. The Don Carlos Estate consists of 2,697 hectares of ranch lands located in San Nicolas and Calao-Calao, Don Carlos, Bukidnon. For many years, the estate was owned by Danding Coangco, a close personal friend of former President Marcos. Following the coup that deposed Marcos in 1986, the estate was sequestered by the succeeding government of Corazon Aquino. In 1993, it was put under the Comprehensive Agrarian Reform Program, or CARP. On May 17, 1995, Certificates of Land Ownership Award, or CLOAS, were distributed to 2,450 ARBs. Long before the Don Carlos ranch lands were taken over by the government, the indigenous group called the Manobos had been trying to recover the estate land. The Manobos claimed that this property was originally part of their ancestral lands. Before the Second World War, a number of wealthy Filipinos persuaded them to lend huge areas of their ancestral domains for pasture purposes. The ranchers promised to pay for the use of the lands and to return them to the Manobos at an agreed time. Following the war, the ranch lands changed hands and the promise to the Manobos was forgotten. They have been trying to recover their lands ever since. When the estate was awarded to the ARBs, the Manobos raised their objections. In 1995, the government tried to appease them by giving them less than 5 hectares in an area that was being used as a dump site. Some of the ARBs resented even this small concession and sought to get even with the indigenous community. On October 13, 2001, 2 Manobo leaders were killed in an early morning ambush within the estate grounds. They were conducting a survey of the land in preparation for their application for an ancestral domain claim. This footage was taken from a documentary produced by Joey Lozano, a Mindanao correspondent of the Philippine Daily Inquirer who witnessed the event.
In the final day of the survey on October 13, guns roared once more. Rodolfo Dasig was killed with a bullet wound on his forehead. He was on his way with 4 others to the survey assembly point. Ananias Tahuyan was hit in the arms and legs, but managed to run away. The assailants chased him on the trail and put another bullet at his back. He died minutes later near the highway.
Soon after this incident, President Gloria Arroyo established an interagency body called Task Force 63 to respond to conflicts between IPs and farmers. The task force was composed of representatives from the DAR, the Department of Environment and Natural Resources, or DENR, the NCIP, the National Anti-Poverty Commission, or NAPC, and the Department of National Defense. Task Force 63 operated for only a year, leaving the contending groups in stalemate. In February 2006, ANGOC held a consultation among representatives of the Manobo community and local officials of the DAR and NCIP. It was clear then that after 4 years, there was still no solution in sight.
Kaya lang, hindi na pwede na ako magkakansel ng kluwa na inisyo ng dahil trabaho namin yon. And that processing are presumed to be correct, proper, and legal that time. Unless ordered by the court for reconciliation, that's the only time you can effect reconciliation. So, bottom line siguro, tama yan eh. Batas pa rin balik sa batas.
The DAR officials presented the following arguments. 1. The DAR does not distinguish between IPs and non-IPs in selecting ARBs.
Pagka kami, sa DAR, ang tumitingin ng mga agrarian reform beneficiaries, hindi na namin tinatanong kung IP ka o non-IP. Pare-pareho pong tingin namin basta agrarian reform beneficiary, you are a Filipino citizen, qualified.
This perception among DAR officials appears to be a major cause of the problem.
Nag-agree ako kay Paro na sa perspective ng DAR, hindi siya nag-distinguish. I think that's one of the fault of government by not distinguishing. Parang sa tingin ko kasi in fact inaccurate yung term na land conflict dahil sa perspective ng IPs, hindi naman siya land. Diba? Parang domain siya eh.
2. The DAR blamed the Manobos for their failure to participate in the beneficiary screening despite efforts to inform them of the ongoing selection.
Dito naman po sa Don Carlos, nakikita natin, sa umpisa, actually priority sila eh. Tinanong kung sino yung magpa-participate. Maraming hakot talaga, pero yung hakot talaga nag-stay doon. Yung namang supposed to be na priority, hindi nila kinikilala. Dahil nga doon, nag-ano po rito yung magbabayad ng yung sasabihin nila na magbabayad. Pero programa po yan ng gobyerno.
At tingin ko hindi lang dahil sa reason na ayaw nila magbayad ng amortization. I think yung bottom line ay bakit kami dadaan sa process ng distribution. Hindi naman yan i-distribute sa amin. Diba? Dapat i-recognize lang ang aming domain sa lugar na yun.
In the end, the DAR proposed to end the conflict by simply transferring the IPs elsewhere.
Kung yung purpose natin is to give land to these IPs, magpapili din doon sa siyang area na konfliktado na marami mga area na open na pwedeng nagyan sa kanila.
Isang problema rin natin sa katutubo, katulad ko, yung tendency namin na babalik talaga kami kung saan kami talagang inimula. Kahit na siguro dalhin natin yung taga Don Carlos, tira natin doon sa buwan, bibigyan natin lahat ng facilities, babalik sila sa Don Carlos.
The NCIP shares the blame with the DAR for the continued conflict in Don Carlos.
If only the NCIP had facilitated the delineation of ancestral lands, then the DAR would have noticed that certain parcels of land are not available for distribution under the Comprehensive Agrarian Reform Law because they are covered by ancestral lands. And by law, by the Comprehensive Agrarian Reform Law, they should not be covered. And CLOAs should not be issued to them. But because of that delay in the delineation of ancestral lands and in the identification of the areas covered by ancestral domains, then we have the DAR entering the picture and covering erroneously, in some cases, erroneously covering the land that are supposed to be owned by indigenous peoples communities.
The second area under study involves the ancestral domains of the Buhid Mangyans in Bongabong, Oriental Mindoro. In Don Carlos, the DAR had already issued land titles or CLOAs to the ARBs before the Manobos could make their formal claim. In the case of Bongabong, the Buhid Mangyans had already applied for a Certificate of Ancestral Domain Claim, or CAD-C, as early as June 5, 1998. While the Mangyans were waiting for their land title, or CAD-T, the DAR made an unexpected move in November 2004. Some 1,500